Number 16, Orozco, and number 15, Jaime. You have no adversary arguing orally, counsel submitted, which I think you know. Please.
Good afternoon, Your Honors. Alina Drucker on behalf of the City of New York. The First Department's decision here is wrong at every turn, and it effectively nullifies the late notice of claim statute. In fact, the notice of claim statute, the underlying statute as well. And I'd like to address those errors as sort of in two buckets. First are all of the errors that go to the actual notice standard, which is a static fact that exists or doesn't exist, whether or not the public corporation had knowledge.
Do you agree that a court could determine that there's no actual notice but yet grant a motion? Or are you saying that that is an absolutely required factor?
So under the statute, the actual knowledge prong is called out by the legislature as the most important, but I believe there could be a hypothetical.
It's not dispositive.
It's not
Otherwise, it would be written that way.
Exactly. No, the statute, it's not dispositive, but the statute makes clear that, I mean, the factors are set out.
So under what circumstances, in your opinion, would the court not abuse its discretion in granting the motion to file a late notice, even when there's been no you can't point to actual knowledge?
Well, it is hard to identify such a scenario, but I suspect it would be one in which the other factors very strongly favor granting the petition. That means both that there would be no prejudice whatsoever to the municipality in defending the lawsuit and a reasonable excuse, among other things.
Well, then, does this case boil down to whether or not there is no prejudice? Or the
No.
record is enough that one would say the court could have come to that conclusion?
No, because a few things, I mean, that's just not how this case was litigated or really
But in terms of the statute?
well, even in terms of the statute, there's no claim, really no reasonable claim here that there's a credible excuse for the delay, nor is there really any briefing or anything as to prejudice. The petitioner's theory has always been that by virtue of the fact that New York City police officers participated in a tort, the entire statute, all of the factors are satisfied, particularly the actual knowledge. And that was really what the petitioner hung this case on.
So it's they filed reports, they said, so there is knowledge.
Well, the question is knowledge of what, right? This is what I was trying to say, the actual knowledge standard that this court has made very clear isn't just knowledge of the fact of an injury. So the fact that somebody came to a hospital and had a bad medical outcome, the fact that someone was arrested, seemingly the prosecution, which is not a city agency, but the prosecutor's office decided ultimately that they couldn't prove the case beyond a reasonable doubt. That does not connote the fact that there has been
So
plaintiff
just
alleges,
because
which is
there
some
was
wrongdoing.
the arrest and there were arrest reports, it doesn't necessarily specify what the harm was that they're suing about, or giving information so that evidence could be preserved, et cetera.
Yeah, not just the harm, but the wrongdoing, exactly. And it's important, I think, to step back and understand the purpose, the legislative purpose here, because the legislature struck a balance. It eliminated the sovereign immunity of a public corporation, and with it created a handful of protections, including the ability to have a quick hearing, and included, most importantly, this notice of claim requirement in 90 days. It's a really easy requirement to satisfy. Within 90 days, you file a notice. There's no real burden.
So what standard exactly are you requesting here? At some point in your briefs, you refer to access to the information. At other points, you refer to, someone with decision-making authority or risk management authority. So what specifically are you suggesting?
So I think that it really does depend on the facts of the case and the nature of the case. But
Okay, but if we want to try to articulate a standard that can be applied going forward.
I think a lot of what this court has already said gets us much of the way there, and the First Department ignored that, which is that there needs to be actual evidence, actual knowledge on that part of the municipal corporation within 90 days or shortly thereafter, which is a static fact.
Knowledge by whom?
Right. Well, this is of both the fact of an injury and of some wrongdoing. And then for that knowledge to be actionable in some way consistent with the notice of claim statute, it needs to be an actor in a position to assess the potential for a litigation for a tort, and to either act on it themselves or refer it to the comptroller. And that means what we know is that the first department's ruling, which is that every single rank and file employee, 330,000 public employees of the city of New York, knowledge on the part of any of them would be sufficient. That's clearly wrong.
So just to press you a little bit on that, and I'm not suggesting this is what was alleged to have happened here, but if you had a circumstance where someone with the requisite authority decided that they would rather not, for example, get certain reports, because that would be sufficient to impute knowledge. I assume in a circumstance like that, where there's some effort to shield yourself as a decision maker who would qualify from any information, that would be a different circumstance, not present here.
Absolutely. That's a completely different situation. And I think the best way to think of it is as a counterfactual. So what we have here is basically nothing. So
Well, wait a minute, why would it matter? If your point is you got to have the actual knowledge, why would it matter?
Why would what matter?
You either have the actual knowledge or you don't, correct?
Well, the actual knowledge is both knowledge of the injury and knowledge of potential
Regarding your
wrongdoing.
response to Judge Halligan.
Well, the
That it would
question
be a
is,
different case if the person who you would say, yes, if they knew, then that would be knowledge that one could impute to the municipal corporation. If that person is actually trying not to get the information, you said that's different. But I thought when you had started this argument, I thought your briefing was you've got to have the actual knowledge.
right, so I think the suggestion, maybe I'm misunderstanding the question, but as I understand it, if there's a person who ought to have started an investigation, who knows about some wrongdoing on behalf of, a police officer, a high-ranking official learns about it and says, I don't want to know about it, don't tell me, we're in a completely different situation.
Again, why does it matter?
Because in that-
If the point of the statute is to ensure the corporation has an opportunity to get to information that would be useful to defend itself before it goes stale or disappears.
Well, the statute doesn't require that the petitioner show that we did an investigation. It only requires that they show that we had an opportunity to do that investigation. And so I'm not suggesting an insuperable burden here that they prove that we did investigate, which is, I think, what the question was relating to, whether or not if we chose not to follow up on it, that's on us. But the fact that we need to have a basis to have that investigation, to preserve evidence, because that's the balance the legislature struck.
So I'm wondering about the requirement that the person, or maybe not quite as strong as a requirement, the person be somebody in a position who has a responsibility to report it, et cetera, because I think in Dalton, right, it was a slip and fall of a student in a parking lot at a school. I think he reported it to somebody in the IT department and to the custodian. Not clear that those are people with that sort of responsibility to investigate a report.
Well, I think it really depends on the facts of the case, right? So I think that the conclusion is on the facts you're suggesting, that in that scenario, there was an expectation that that would be sufficient to meet the requirements of the Notice of Claim statute, which is that somebody probably had a responsibility, a reporting responsibility. There's something else that's lacking in the first department's assumption, is that there's a presumption, basically, that we presume that just because of the participation, in fact, the intentional misconduct of an officer, that would be hidden, sort of by definition, based on the description.
Well, that seems to be an important point with regarding this case. Right?
Yeah, so I think that the question about whether or not, so this is all to that, whether or not there's actual knowledge, whether or not the circumstances are those that would prompt an investigation and settlement of claims, or could prompt an investigation of settlement of claims, is critical. And here there's sort of multiple problems. There's problems that go to whether or not the facts, as they're alleged, they're stated in the alternative, so it's even hard to identify what the exact facts are. But whatever it is, the theory is not one that shows both what happened and who knew about it. And then moreover, what's presented with an attorney affirmation and no evidence whatsoever, no basis for the trial court to exercise any discretion. And what we're saying is that when there's a fact question about, is this the kind of scenario under which someone should have acted?
Well, the problem with no evidence, I think, is it's a little bit inconsistent with where you started earlier, that filing the notice within the time period is a very easy thing to do. I mean, the heavier you make that evidentiary burden, the harder it becomes to do.
So I think this is, and my time is over, but if I can answer the question. This is critical difference between the notice of claim and the late notice of claim. What happens is that the notice of claim is a calculation made by the legislature that within 90 days of a tort, the petitioner just has to let the city know of a potential claim, and that's the end. And then as a measure of legislative grace, in response to concerns that that was too harsh in circumstances when the city had the functional equivalent of a notice of claim. So the city already knew about the claim and should have investigated it anyway. In that narrow situation, what this court described as exceptional cases in Beery, there was the ability then to file a late notice of claim petition and ask the court to adjudicate, oh, this is the functional equivalent of a notice of claim. You had that notice. And so that evidentiary burden that I'm suggesting, it's not a particularly high one, but it is when you're filing a petition and you're starting a special proceeding asking the court to find that you've had the functional equivalent of a notice of claim and you've satisfied it, then you have to put it forward more than just an attorney affirmation that in boilerplate alleges really the elements of a tort claim without really any accounting for whether the municipality knew about it within 90 days or shortly thereafter and could have acted on it.
I guess, if I may, the question then becomes, how would they know about it if they don't have access to records?
Well, they would know about it because imagine, let's take Mr. Orozco's claim. If we were to spin out, I don't know enough facts about his claim because it's stated at such a high level of generality, but let's say he pled a more concrete theory. He said, an officer lied, and after the officer lied, I didn't file a notice of claim, but I did, this is a static fact, I did put the city on notice in another way, and I did that by filing a complaint with the CCRB. I did that by making it clear, the district attorney, I told them about these lies, they were uncovered, my case was dismissed, and at that point it was referred for discipline. Because there's a whole set of procedures in place in the city that could provide a functional equivalent of a notice of claim, depending on the facts, and that's where it's a fact-bound analysis.
If I'm understanding this point now, you're saying that regardless of whether or not the municipality has in place mechanisms to surface on its own without a complaint, if there has been misconduct, right? That in those kinds of cases, that the individual has got to come forward and at least alert them in some way with some kind of complaint.
Yeah, and I think the way that that makes sense is to say with a false arrest claim. When you have a person who's been arrested and then subsequently
It does
case...
incentivize, does it not, a municipality not to put in place those kinds of ways to ensure that you're constantly identifying when let's just take the police for the moment, police are perhaps acting inappropriately?
Absolutely not. I think there's a couple of things. One is that I think that primary tort liability, while an important factor, we have a whole nationwide movement for police accountability, and I don't think that the legislature's judgment about when the public fisc should be open to tort liability and when it shouldn't is really a question about police accountability. But I do think if we're going to have a principled rule on the late notice of claim portion, the question is whether the police departments, whether a petitioner who says, I provided notice to the city, if what we're suggesting is, oh, well, some police department somewhere in the state might decide not to follow up, that doesn't protect them from tort liability, because the whole threshold question is only whether or not there was adequate notice, whether in the form of a notice of claim or, as the court sort of recognized in the late notice of claim, a slightly more flexible but still functional equivalent to it. So whether the attorney, the insurance carrier, or the public corporation in a similar capacity knows about the claim. Whether or not we then act on it for purposes of police accountability is sort of neither here nor there for whether or not tort liability
And
is available.
presumably, any result here would apply across a very wide range of claims. So, for example, if you shovel, the snow, any range of the wide variety of claims that the city is on the receiving end of.
Exactly, yeah. And General Municipal Law 4 establishes that the notice of claim requirement applies for all negligence claims and all malfeasance claims. So we're talking about across-the-board tort liability, and the legislature doesn't provide a basis to distinguish different types of claims, which is what the First Department really did here by saying, oh, intentional conduct or police and corrections conduct is different. It's a result that's not consistent with the statutory scheme, which at this point, this statutory scheme is really just about the notice of claim and the tort liability. My time is up, so unless you have further questions.
Thank you.
Thank you.
Good afternoon. May it please the court, Lorenzo De Silva on behalf of the city. As my colleague explained, the First Department's analysis is wrong at every turn.
Counsel, can I ask you
Yes, Your
something?
Honor.
It seems to me there's two different ideas going on here. They're a bit conflated as I look at it, and maybe this is the wrong way to approach it. But it seems one theory was this is an intentional tort, as your colleague was saying, so the city actor must have known you were on notice, right? But there's also a theme, let's say, that there are documents somewhere in the system that's at least set forth the activity that was going on here. And those separately would also be, enough to give you notice, more along the lines of Wally G in the other cases. Is that right, or are those two ideas somehow merged here?
I think they're independent and interrelated, but regarding the sort of animating idea behind the First Department's analysis that, well, you paper over everything, you can just go look at the documents. That's really about prejudice and the ability to reconstruct whether a tort happened after the fact. But as my colleague was referring, actual knowledge is a static fact that you have to look at, did it exist within 90 days or a short time thereafter? And another response to your concern, Your Honor, is that if you look at the Wally G and the Williams cases, even in those cases where you have licensed professionals who are doing diagnostic evaluation and reviewing or building a chronology every time someone comes into a municipal hospital, even then the court said, look, we need to be able to say that a particular record evinced an injury fairly traceable to an actionable wrong by someone working for the city.
No, and I understand that. I guess my point more was that they're really two different issues or information facts that go to two different parts of the analysis. Is that what you're saying? So that we need to reach whether or not in the intentional action by the city, the officer, is enough to give notice because the documentation issue goes to prejudice?
So I think there's statutory and doctrinal reasons why the scheme that the legislature came up with doesn't differentiate between the types of torts or the fact patterns and contexts in which they could arise. So that's one answer why the First Department's focus on intentional action is wrong. But the second answer is if you look at the 5 virtually identical proposed notices of claim in the Jaime matter, they are full of boilerplate, and they're honestly intentionally cagey about what this petitioner is saying even happened to him. So what's more egregious in the Jaime matter than in the Orozco matter is that the First Department said, no matter the claim he is raising, no matter whether it sounds in negligence or intent, no matter the way the injury arose and how the municipal respondent is
But
related
counsel,
to that.
what I'm really trying to ask you is, in terms of notice, do we need to reach the intentional tort issue? That's my issue. Or is there something else going on here with the documents as well? Is that really what's underlying the notice issue here?
In the Jaime matter?
Here, yes, your case.
Well, I just don't know what the tort is that the petitioner is alleging on each of the 5 occasions, so that's problem number 1. There needs to be something in the balance for the court to weigh. And then the second point about the documents, it's just not the case that just because we know that documents will be created in the ordinary course of business.
I'm not sure why you say you don't know what the torts alleged in each of those 5 incidents is.
We know that he was injured.
Well-
He says assault and corrections officers and/or other inmates.
So doesn't he identify the officers, for example, in the first one?
He identifies the officers and the time and place, and that might go to prejudice, but it doesn't tell us why at the point in time or shortly thereafter we would have a reason to be doing the functional equivalent of the investigation that would have been prompted by a timely notice of claim in each of the 5 instances. So just to round out the point, no matter the claim that are raised in the 5...
So, sorry, let me just back you up there. I was just processing your answer. So your view is that the actual knowledge has to be of facts that are sufficient to have caused the municipality to investigate?
Yes, because that's at the core of the statute. If we don't have timely notice of claim, which will prompt an investigation by the comptroller, we're asking if there has been a functional equivalent. And the fact that someone misjudged the use of force when trying to maintain control of an inmate, or maybe punched him because he didn't like the way he looked at him, or perhaps knew that a particular inmate or a group of inmates, had it out for him and should have protected him. All we know here is there's some sort of injury. He says something along the lines of, well, he told people to look out for me.
It shows a fractured arm in the records, or no?
In one instance, there was a fractured arm. In another instance, he alleges stitches. There's no documentary or record support for that, but the notices of claim do purport to allege that.
But the infirmary records don't show a broken arm.
If the question is, let's just go look at the documents and see what they say, that really goes to prejudice, and it makes sense that in the context of prejudice, we know what...
Does it only go to prejudice? That is, if there's a prison infirmary and an inmate comes in and has a broken arm, you would think that they'd want to know how that happened.
It's possible that that information might never be shared because there could be an inmate who, for whatever reason, doesn't want to disclose the cause of the injury, that it was another inmate or another officer for whatever reason. And so it will depend on the facts and circumstances of each individual case, but if we had potentially a personal affidavit from the petitioner who said, these injuries happened on these dates, I went to the infirmary, I told them that this is what happened to me, that would be an entirely different matter than the bare bones, mere allegations that we seem to have here. So there needs to be...
Is one of your issues here that the attorneys verified these as opposed to the petitioners?
That is one of the issues here. So
Why is that problematic?
So the attorney is basically saying that on information and belief, these things happen. It seems that maybe he had conversations with his client and put in the best that he could, but it's still so boilerplate that all we know about is the injury, not how it's fairly traceable to an actual wrong, much less how we had actual knowledge or something else to have prompted an investigation close in time or shortly thereafter to each of these incidents.
So it's content-based, not through the vehicle of which it comes to your attention, it's what it is.
I think there's multiple layers of errors in the First Department's analysis, and it could be, in the Jaime matter, easy to correct, one of them without having to delve into more thorny issues. But I do think both the lack of record support beyond a very bare bones attorney affirmation and notices of claim, the fact that we have no information about why the static fact of actual knowledge as to each of these 5 incidents would have existed at the time, and the very fact that I'm not even sure what it is he says caused his injury. So how is it that a court could even begin to exercise the...
What if he said it's certain officers and named them and certain inmates?
That would potentially allow us to reconstruct the tort after the fact, but that doesn't tell us whether there was some basis to know.
If you can reconstruct the tort after the fact, what's the prejudice? If we disagreed with you, would you be able to go and defend?
So in this particular case, there was no independent argument on prejudice except for the showing on actual knowledge. There could be some case where there was an independent showing on prejudice, and as you were just asking my colleague, there could be a set of facts where no or very weak showing on actual knowledge and potentially a very strong showing on prejudice, reasonable excuse, and any other facts and circumstances that are relevant to the case that could get the petitioner over the threshold.
Is your answer, because that's not been raised, you don't know the answer?
I'm sorry, what has not been
Is
raised?
your answer that because this is not really in the case, that's how I understood your answer, this is not the argument that was made below, it's not what the court relied on, that therefore you can't answer my question? You don't know if there would be prejudice?
It's possible that we can make a showing on prejudice, but because I looked at the papers, our argument in this case was that the petitioner never shouldered their burden, so I don't believe we came up with a particulars showing. But everything in Jaime depends on this idea that there must always be records, and if an employee knows something, then that must be sufficient to prompt an investigation. There's problems on the outer bound of, there are some reports that could be sufficient, there are some people's knowledge that might be sufficient, but the appellate division accepted the inverse and just vitiated the statutory protections that the legislature carefully considered in striking a balance between, on the one hand, equity for those who have been injured and the protection of the public fisc and the taxpayer-funded services. Because in so many different ways, the Jaime analysis is just wrong and really muddying the waters that this court's case law had made clear. The First Department just ignored that. That's why a reversal is required in the Jaime matter and the Orozco matter as
You
well.
also agree, as did the other counsel, that there is no dispositive factor. That's not the way the statute reads, not the way we've interpreted, or do you understand it differently?
I agree that the lack of actual knowledge wouldn't necessarily be fatal, but in this case it is.
Because,
Because he did not shoulder his burden on reasonable excuse. He offered nothing in the way of reasonable excuse, and his only argument on prejudice depends on the argument on actual knowledge. So if actual knowledge is out, we have nothing on the table.
so then it's because, putting aside the actual knowledge, it's because he didn't come up with a reasonable excuse, and because there's no prejudice, even though you told me you couldn't actually argue that?
Well, there's no actual knowledge, and the prejudice that,
But I thought you had said, yes, you could have a case where actual knowledge is not the dispositive factor.
if there were an argument to satisfy the initial burden on prejudice, which there isn't here, so this case is, not that.
What would someone have to do to satisfy the burden
So-
on prejudice?
On prejudice,
It
so.
sounds like you're saying, yes, actual knowledge need not be a dispositive factor, but if you have the combination of no actual knowledge, you don't really have a reasonable excuse, and you can't show prejudice, that's the trifecta, you can't get that late notice of claim motion granted.
I mean, that's our general theory, but I also want to echo, apologies, I've lost my train of thought, but the point that my colleague was making about there are vehicles by which someone who is a pretrial detainee at Rikers can create records showing that their rights have been violated. And we actually have some proof that this petitioner knew how to do that, but didn't do it in connection with any of these. That could be sufficient on prejudice because you could put together an event after the fact, but we have no records, we have no record
Are
support.
you referring to his having filed grievances before?
That's correct, that don't pertain to these incidents.
And the paperwork that he refers to here isn't causally connected to what he claims occurred?
That's correct, because none of the grievance, I believe it was money in his account, and he refers to an altercation with a correction officer, who I don't believe is one of the named corrections officer, and there's no more information provided about what the altercation is, and I don't believe it's any of the dates that he identifies in the proposed notice of claim. But to go back to Judge Rivera's concern, there are things that a detainee can do if their rights are being violated, and so they don't even need to know about the notice of claim statute to be able to file a grievance, to be able to file some other complaint, seek to have an officer disciplined. There are ways to do this, but here,
That seems to go more to notice than to prejudice, right? I mean, even if you sent grievances like that in, you might still be prejudiced because evidence has evaporated or whatever by the time he sent it in. It's really more...
that's possible, but at least then there would be a threshold showing on prejudice so that we'd have something in the mix to be balanced. Here we have,
So I'm not following why that's a threshold showing on prejudice rather than substitute notice.
because if all it depends on the contents of the grievances of the complaints, but the fact of the matter is that someone can put the municipality on notice separate from timely filing a notice of claim. That's not what happened here, and it's, here we just have the presumption that there must be records, there must have been caused by some correction officer, they must know this, so there must be actual
I
knowledge.
can ask one last one, I think. What if an inmate is afraid, this may be a little bit of what you were being asked before, is afraid to complain, feels that they will be retaliated against, and instead looks and says, I've just got to hold out a certain number of months, 13 months, 14 months, 2 years, whatever it is, then I'm going to file.
So, I mean, that could...
And then they do. Once they're released, then they do.
So that might go to reasonable excuse, and the statute does say all relevant facts and circumstances, so there could be a case where the argument is made that those are the facts, and so there's such a strong showing on reasonable excuse, maybe the time is very short, so the balance of factors might, depending on the facts and circumstances of the case, weigh in favor of leave there, but none of those factors are present here.
Thank you.
Counsel, one last question, if I can, Chief. Can you give us a quick sense of the other types of tort claims that the city faces? And if you happen to know, what percentage of your docket, your tort docket, is in the corrections context as opposed to other types of tort claims? Just roughly, if you happen to know.
I don't happen to know, but I do believe that we cite statistics that we've compiled in the city in either our opening brief or a reply brief, and I would go back there if I were reporting back to you to
I'll
look
check.
at those, because they might break them down by carceral setting, by police activity, more ways like that. But it is a substantial number, and the problem here is that basically the First Department has blessed a framework where up until 1 year and 90 days after the fact, if it involves police, if it involves carceral setting, there must be actual knowledge. And
But
that's
I
just not
assume,
consistent.
my question was, I assume that you have some set of claims that are outside of the carceral and
That's
the
correct.
police context. And so, just very briefly, what types of claims might that encompass?
So it could be, a trip and fall claim, a motor vehicle collision involving a city vehicle, whether as the one that hits it or the one that hits the car that then hits the person who's injured. There's so many different variations on it that it's such a frustrating answer, I know, to say it depends on the facts and circumstances of each case, but it is the case that the First Department's errors here don't draw any distinction, and that distinction is not based on a good faith reading of either the statute or this court's case law.
Thank you.
Thank you, Your Honors.